This is Michael Foster with Foster Estate Planning again, and we're going to talk in this segment about data gathering and the data gatherer. On our website, under the products that are available, there is an icon or button there that you can click to download our data taker. And when you do that, it's asking for a lot of individual detailed information. And what I wanted to do is kind of go through that and talk to you a little bit about that data taker, and just talk to you in general about estate planning. We feel that probably the most common estate planning purpose when we sit down with estate holders and spouses as far as what their intentions are with regard to their assets is that most people want to leave as much of their stuff, and I often refer to people's estate, their assets, as their stuff. That's probably the simplest definition of your estate. They want to leave as much of their stuff as possible to the people of their choosing, to heirs that they've identified, with as little of it going to outside parties in the form of costs and expenses as possible. What they're looking for is for efficiency. And we feel it's our job to try to help them achieve that. And one of the biggest problems we have in estate planning is that people put it off, and they wait too long, and as they wait, some of the different planning options that might be available are no longer available. It's procrastination is usually the biggest problem. That's why we're encouraging people as they listen to this, if they want to submit something, check that data taker, download it and fill it out and email it back to us at www.fosterestateplanning.com. And we'll be happy to come up with some solutions and some recommendations on how to improve their situation. People put the planning off not only in terms of taxes, but there's three things to plan for. The three big D's in life are death, disability, and divorce. We really don't do a lot of planning for divorce, though we have put together recommendations about prenuptial agreements and how to plan for starting over again after a divorce. But we do participate quite a bit in planning for disability and for death. And one of the problems that happens is people don't just necessarily die, but they become incapacitated. And when that happens, then you've waited too long before you've been able to figure out how to deal with your assets. And in that situation, if you're no longer mentally incapacitated, we can't change directions or make up directions for you. And so it's important, while you're of sound mind, to keep your intent and your directions up to date in written form. And we have videos here on living trusts, videos here on planning for large estates, and some recommendations for disability planning for different people. And you might want to look at those when you're done looking at this. But what we want to do is just touch briefly. What we're trying to do in the data gathering is we're trying to get a picture of where the estate is at. There's two types of information we're asking for. We're asking for family information and financial information. And from that, then we'll figure out what the costs are when the individual passes away. And we'll figure out what it's going to take to change that and reduce or eliminate those particular costs. And then we'll, of course, give you a fee quote on what we would charge to do that. We don't have any charge for you to upload the data taker to us and to do an initial calculation and show you what your costs and expenses are going to look like right now today. And then what we'll do is we'll give you an idea of what we think we can get those to, and then there'll be some fees, and we'll give you a complete schedule, a complete disclosure of what the costs would be to assist you in implementing those different types of planning recommendations. Then the next thing is that we need all that family data we talk about in the data taker, because we're trying to come up with goals and objectives of clients, and different families have different goals, different objectives, and different needs. There's no one particular recommendation that always is going to meet everybody's need 100%. What we're looking for are those particular devices that eliminate as much risk of missing your intent, missing your goals and objectives as possible. We're looking for quality advice that minimizes the risk of missing your goal. And that's why we have criticisms of things like joint tenancy, because you don't know who's going to die first, you don't know who's going to die second, and you don't necessarily know what the circumstances are going to be of the heirs to the person who dies second. Joint tenancy with a husband and a wife doesn't mean that the children aren't going to get the assets, because the second party could remarry, and if they don't do their planning correctly, it'll all go to their second spouse's family. So it's important for people to sit down and give these things some consideration. We've got up here on the slide some of the different goals and objectives we want to provide for. If a person has a spouse, they usually want to provide some sort of control and income for their spouse. If they have heirs, there's different kinds of heirs. There's heirs that are involved in the family business, and that means that they need that to sustain themselves. Now, if it's a family farm, there's a lot of equity involved that can be severely estate taxed, and it's important to keep that together to have the same income. In farming, it takes a lot of equity to produce a little bit of income. And so if you've got a couple of families dependent on that equity, it's going to be important to find a way to transfer that and not have a lot of other participants in the equity. So we're going to have to look for some methods of business continuation, and that'll be another video, another segment that we're going to have. We also are looking for the anomalies in the family. We're looking for the divorces, we're looking for the blended families where his kids aren't necessarily her kids, and they'll have differences. A husband and wife can have differences in how much they want to go to different parties. They may not necessarily have identical mirrored estate intentions, and they need to give each other the flexibility to realize they maybe don't have and shouldn't have mirrored intentions, or maybe they should. That's up to them. If there's addictions or disabilities in the family, if you leave somebody an inheritance that's on state and federal assistance, on Medicare, Medicaid, it can disqualify them until they use up and burn that inheritance, until they've totally consumed it, and then they have to reapply after that process is completed. We're going to set up some hypothetical data here in this session and kind of show you what we're looking for. We also want to minimize federal and estate taxes. In my practice as an estate planning attorney, much to my chagrin, nobody ever wanted to include me as an heir. Nobody wanted to leave me 5, 10, 20, 15% of their estate. They always had me over on the liability side, and they're always looking to reduce the attorney fees, including probate attorney fees, as well as some of these other expenses. We also can have issues where we may have to do planning for multiple generations, particularly on businesses and farms, because if we're going to transfer a big asset like a business or a farm from mom and dad down to kids, down to grandkids, we may need to do multi-generational planning all the way down the road there.